No,
They can hear me? You sure? Now they can. But I don't think anybody
well, no, because they heard you through the polycom, but Mr. Grisling has not put his appearance on the record. I am correcting him.
Amy Rende versus Drummer.
Okay, you're good.
Good afternoon, Your Honor. Robert Eggerson on behalf of the plaintiff.
All right, your name? All right. And where are we on this case? This is...
We took a judgment on October 10.
Yes.
And the defendant filed a motion to set aside the default judgment, saying she had some issues making it to the hearing, doesn't believe she owes 10 grand, and she would be out by, trying to read her motion, I think it's October 20, and of course she's not out. We have now filed, she's not filed a bond. We have now filed a motion, an application for an eviction order.
All right. What do you want to tell me? Because it does say that you were going to be leaving in any event. Pardon? You did? So you're out of the apartment? Okay. And so what you're doing is you're challenging, saying that you don't owe that amount of money. How much do you think you owe?
Something she said for rent, and then Termination solutions to
Which is,
under 500.
you think you owe under 500, they think you owe 10,000. Did you pay the last month's rent? Were you terminated from Mist at all?
No.
Okay, well, at this time, you're out of the apartment. And at this time, I do have, so possession's been surrendered. Have you have documentation that you can submit to the court that in terms of payments on the account?
When was I supposed to be?
Did you have any portion you were paying?
No.
All right, then what you need to do is you need to get to Misha or whoever your worker is, get to the quarter ledger that indicated that they paid your rent and that you weren't terminated or they suspended your subsidy. Okay, so what I'll do is I will put this over, I'll give you 2 weeks to get that into the court. You need to send a copy to opposing counsel, so I'll adjourn this to November 7th,
I've also submitted
2025 at
1 p.m.
1 p.m. I'm sorry?
lawyer the pictures because she had that's probably if she wouldn't attention. That's why I was in her property for so long, because she wouldn't come abide by the rules and she couldn't pass inspection for 3 months. So that's why I remained.
All right, I'm going to decide your motion. You've already given possession. Defendant has given possession. And then in essence, the only thing that you're challenging is the amount of the money judgment, but I'll take a look at that. I would imagine that most of this may be rent that wasn't paid, or at least a portion of it. So you need to provide that to me and provide any other documentation that says that the unit, that you didn't cause any of the damages they're claiming. Understood? All right, we'll see you in a couple weeks.
At 1 o'clock, Your Honor.
Yes,
right?
sir. Yes,
Thank
sir.
you, Your Honor. Have a
Thank
nice
you.
weekend.
You do the same. Ava Holdings LLC versus Andrea Bradley.
Good afternoon, Your Honor.
Yes.
Appearing on behalf of the plaintiff, Ava Holdings.
Your name? Okay, where are we on this case?
Going to enter consent on this matter for agreements. And we'll just take that to the court.
You're going to enter a consent judgment? What are the terms of the consent?
It's just a possession. And no money damages until the end of November. So,
So a consent judgment with a move-out date of November 30th.
There are a lot of action to rent,
Pardon?
and I have until the move out date to get from the funds that's required for that.
Is that part of the agreement? You understand that, ma'am?
it just is not an agreement. That makes sense.
It's not what?
That's not part of the consent agreement, no.
That's an agreement outside of it. Okay.
And you're comfortable with that, ma'am? All right. All right. Do I have a judgment that she signed?
After 28th written, let me just change this.
All right, ma'am, you've signed off on that. Do you have any questions regarding anything contained on this? All right. And I will enter this judgment by consent. Ma'am, I do have to advise you that you have 3 business days to think about this. If you believe that there's some legal right you didn't assert, some misunderstanding or confusion on your part, you'd have those 3 business days in which to file a motion with this court to set this aside. You understand that? All right, very good. Thank you. Wait. I don't know what. Oh, gee, let me do that. Right. Court calls the case of Clara Ganon versus Holly Ellison. I can't believe I broke them.
Good afternoon, Your Honor.
Good afternoon. Your name? Okay. I know that was the student attorney, but he stopped.
Your Honor, first of all, I can't hear what's happening in the courtroom.
Okay, I know. Our system is partially down. I've been operating with this all day. I will repeat whatever I can repeat that may be necessary. So, but you go ahead. I can hear you.
Okay, great. I'm Ike Start. I'm here with my partner, Anushka Jalaseki. We're student attorneys requested to appear on behalf of Ms. Ellison pursuant to Michigan Court Rule 8.120 under the supervision of attorney Santa Crochet, who I believe is here by Zoom.
I see him.
Okay.
Have you been before me before?
No, I have not, Your Honor.
Where are you from?
Originally from the Grand Rapids area.
Okay, so you're Michigan.
That's right, Michigander. Yeah.
All right. Where'd you go to undergrad?
I went to Calvin University, which is a small liberal arts college in Grand Rapids.
It's like people think I'm like crawling from under a rock. I know where it is.
Okay.
She's like I don't go anywhere. All right. She's a pizza. Okay, now you're at U of M. All right. I guess I'll give him permission to practice. Permission to practice is granted. Go ahead.
Thank you, Your Honor.
All right. Where are we on this case?
Yeah, I'll take it. Since the last hearing, we've had fruitful discussions with Ms. Gannon, and I don't want to speak for Ms. Gannon, but I think we're very near to a resolution on this case, and we were discussing a conditional order of dismissal. We've talked to MISJA, and they've agreed to pay a large portion of the back rent that's allegedly owed in this case. Our client, Ms. Ellison, has an appointment with Hawk on Monday to try to generate some funding there. In addition, we know that it's important to Ms. Gannon that Ms. Ellison be leaving the apartment complex, and so Ms. Ellison is actively looking for and applying to other housing options. So I guess at this point, we'd request an adjournment for another 2 weeks. That being said, Ms. Gannon and I and our team are I think pretty close to getting a resolution here. So if we draft a conditional order dismissal, we can file it and cancel the hearing if necessary.
You can tell he goes to Michigan. He talks a lot. No, but I actually understood it. He didn't use any of those big words those Maryland guys can't understand. Ma'am, is all of that correct?
Yep.
See? Simple, to the point. All right. Will a couple of weeks be enough for you guys to get this done, or you think?
Yes, sir.
All right. Okay. I will adjourn the matter to November 7th, 2025 at 1 p.m. Okay?
Okay. Thank you.
All right. Thank you. Have a great weekend.
You too.
All right. And good luck to your football team.
Thank
All
you.
right. Court calls the case. Group 5 Management versus Winston Johnson.
Afternoon, Your Honor. Robert Weiss, Wayne State University.
Yes, sir.
Mr. Johnson is not checking.
Mr. Johnson has not checked in. Did you wish to take a default, sir?
I do, Your Honor.
If you raise your right hand, do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
The amount owing is $253.42, inclusive of court costs. Requested judgment for possession and money judgment in that amount. Writ to issue in 10 days.
You said 253?
253.42.
42. So that's basically court cost.
Yes, a little bit more than court costs.
Gotcha. Very little bit more. Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with a writ to issue in 10 days. No writ without a hearing.
No writ without a hearing?
Yes, sir. I
Okay.
do that when the balance is really low. Maybe they just forgot to pay it.
Who does
All right.
Maryland play this week?
I have no idea. They've disappointed me the past 3 weeks, so
Yes, I know.
I
was
been-
thinking about you when I saw the scores.
so I've been crying and not looking at their schedule. I'll figure it out tonight, though.
All right.
right.
Have a nice weekend, Your Honor.
You do the same.
Okay. Bye.
Bye. Dave Prada versus Seth Burton. All right, and where are we on this case, folks?
So, Your Honor, Mr. Barton raised some defenses at the last hearing 2 weeks ago. We instructed him to file an answer to the complaint. I never received that. Yesterday, I called my assistant, called the court, and we saw that he did file something yesterday or the day before. So the clerk here was nice enough to email the answer to me. I got it up yesterday. There's a lot of allegations in there. Mr. Potter, I did also get the answer emailed to me overnight after midnight, and apparently he taped something in this case, which I believe is the answer to a loading dock door at Dobbins Farms where my office is. I just got that notice when I was sitting in court here. Basically, in his response, he admits that he has vacated the premises. He's abandoned the property. He's done that since the beginning of July.
Can I reject that? That's nothing like what I said in my statement.
Oh, okay. Let me just, because that's what I kind of gleaned from this. Are you in the property or not? Pardon?
House is filled with mold. The water filtration system has been disconnected and the pipes are still leaking into the base. Trying to get my stuff out of there as fast as I can. Working on it.
Okay, so you're not living in there, but you have property there.
Mold. So in order to move it, it needs to be cleaned before I can bring it into my new house. And I got a staph infection from dealing with all the mold. That's why I was late turning in the paperwork. I have a doctor's note, easy cream.
So, Your Honor, the most important thing here is that my client get access to the house to remediate the problems that are in there. There's no debate that there are problems. How those problems are caused, those are up for discussion because we believe that defendant significantly contributed to the mold problem by not allowing access, not allowing remediation.
Okay, look, this is not a trial. So the whole objection thing that you see on TV, you wait till I tell you you can talk. Go ahead.
So what we're looking to do, my client has notified his insurance company about this whole problem here. And they said they're actually going to drop him by the end of the month if he does not get in there to remediate the problems. So what I guess I can do under the lease, if he's not saying that he's moving out or moving out his possessions, to the very least, I can exercise some language under the lease that says that we can get in there with 24-hour notice to the tenant. So we're giving 24-hour notice to tenant that we will be in there on Monday morning to start remediating this. And his possessions in there, you can see that it's quite cluttered from the pictures that were attached to his answer. Some things are going to get moved away from the furnace and other things that need to be repaired. We will not throw anything out until further order of this court, but we are going to be getting in there to remediate this immediately.
Go ahead, sir. What do you want to tell him?
I've never with them for my access to the house. They've got keys to it. The lock is the same. The only thing I did was disconnect the garage door because every time I kept coming over there, it was wide open with all my stuff there for somebody to take.
Okay.
Also went into the house, all the windows, left all the doors unlocked, and a lot of my stuff got rained on now the last couple of months. And that's been ruined upstairs where there wasn't even a leak from the pipes. That's also shown in the picture.
What, they left the windows open?
Lock all the doors, turn all the lights on, pull the screens up, open all the windows, and not rained inside the house, Your Honor. My couch is now ruined. I've got a laptop that's ruined. A bunch of other stuff got wet. And this has been going on since.
Okay, so in terms of their notice that they're entering the premises to remediate, you don't have an objection to that. Didn't ask you whether you ever did. Listen to my question. I don't need the superfluous language. Do not have an objection today, correct to that? All right, they will be entering the property. They will be able, for the purposes of remediation and protection of property and preserving the property pursuant to the court rule, I think it's 4.201H. And you are not to destroy or remove any items except by order of the court. All right. So if you want to prepare an order to that effect, which we may need one just in case, I certainly would appreciate it. And then when do you guys want to come back? Because you're going to have time to review thoroughly the answer that has been answered and presumable counterclaims. 2 weeks. Will that work for you, sir? During this matter, November 4th, 2025, 1 p.m. November 7th. I don't know. Why am I writing the 4th?
Because it was a Tuesday date?
Oh, you're right. 1 p.m. Okay, so I haven't completely lost my mind. All right. Thank you. Court calls the case, Bell Asset Management versus Skylar Asher. Go ahead.
And case P7292 for Bell Asset Management and Medina University, since everybody else with that.
All right. And your name? All right. Last time we were here, or this case was called, there was $3,716. Is that where we still are, or?
Basically, Ms. Asher, at the last hearing, we were just, that is the right to retain if she wanted to stay in the unit. However, she said at the last hearing that she had vacated the unit, forgive me if I'm wrong, correct me if I'm wrong.
Yes.
And she has nothing left in the unit. And she's reiterated that to me today. Unfortunately, it took a little bit of doing, but we actually do have, we filled out a conditional dismissal, but it just basically says that she's
Well, why would we do that? Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. You are no longer in the unit at 120 South Prospect Street? Okay, and you voluntarily are surrendering that to the landlord, Bell Asset Management? But you are surrendering the premises and any right to the premises? And so they may re-enter the premises? And anything that is left in there that may be property of yours, would it be okay with you if that is defined as abandoned and that they may just get rid of it?
Yes.
All right. I think we're done. You can take possession of the unit and I can dismiss this case.
thank you.
All right. Yeah, no, I know. You're trying to get there. After that last case, yeah. All right. Thanks, guys. You guys have a great weekend. Haverhill on Clark versus Jeffrey Thompson. All right. And this is a termination. The basis for the termination is?
The basis for the termination of it was that the defendant was served a notice to quit based on lease violation. And those were served to the department. And on August 14th.
Via the attached letter, I do see that. All right. What's your position on this, sir?
Proceedings going up, but I've been working with Lease services for South Central Michigan. And
Okay.
they're going to bid and have the resources available for the deal with the day. I think it's miscommunication that it said in their letter that they want me to meet with them within 10 days.
Meet with who? Who? They did?
They seem to do either match, and I don't really know. But I emailed the property manager a couple different times trying to set up a big meeting. And I have an outstanding relationship with I think they were a team. They're great people. And she got back with me and she said that management wasn't.
That what?
Man, couldn't meet with me. They couldn't meet with me, so they were going to move forward with their legal process. And
What were they, for your understanding, what were they going to meet with you for?
Situation that happened. I had an opportunity to tell them what happened. Like, they have help, but you know.
Okay. Anything from this side on that? Your name?
The next, the community manager. I
Great.
did reach out and responded, also let know that I reached out to the regional manager and she declined to meet with him because like you said, it was kind of over her head at that point. Already had just kind of wanted to cut ties and terminate the lease agreement because of the damage that happened to the property. And incidents that happened that recurring incidents that happened.
The incident that happened was his fault?
I can't really pinpoint whose fault it was from Pittsfield Township's report when they came out to the property. They stated that they had a history with him. So we pretty much delivered what they provided to the manager. She decided that this is something that's going to happen again and get my daughter to keep taking hits to the property with the damage. And then we have several of our residents that are trying to move due to the incidents because they feel safe.
What was the specific incident?
So it was not one site that I did receive a phone call from Pittsfield Township. They came out, there was blood in several areas of the building. The fire alarm had been pulled from fire department had been out, fire. The glass where the fire extinguisher is, it was broken. I believe they said they found him in a state of undress at a nearby medical facility. And like I said, they said that these are recurring issues. So because of that, the regional manager decided to just move forward and terminate the lease agreement.
You say you're working with legal services. Are you going to file an answer to this complaint? Pardon? What were you saying?
Trying to sleep at night, having this over your head. I've been working with legal services, but today Alex had mentioned that I guess it was the complaint was, he said, I think it was incomplete because section 6 had been for but they actually see some of the events and it passed a couple days prior to that time. Because of things that I didn't want to do that evening, I was hit. And I tried to get any attention that I could that time from my neighbors.
When you say you were hit by somebody?
Yeah.
So you're indicating you were a victim of a crime which caused this sort of escalation of things. Part?
I was scared. I just needed to get out of there. So
Pardon?
I was scared to get out of there. So I tried getting a hold of anybody that I could and no one answered. So I mean, they probably have a camera too that person was there. I don't know. I just feel really bad. I just wanted
All right. Well,
horrible things. You have some health issues that we're working with CMH on, but I keep on doing it up. But I was listening to the radio. They would come across the hall, just came across last weekend with cupcakes of all things for Halloween.
all right. I need a written answer to the complaint. I'm going to, if you get to Mr. Henry They should be able to help you with that, but I'm going to put this sort of on a fast track here. I need a written answer to the complaint by. So let's do it this way. By November, no, by the 31st. Okay, by October 31st, I need a written answer to the complaint. And then I'm going to set this for a final settlement conference, the prelude to trial if we have to have it. I'll set that for November 4th, 2025 at 9 a.m. That's in-person proceeding.
Sorry. So.
Thank you. Casey Zhang versus any and all occupants at the 383 Sedgwood Lane.
Your Honor, in case something 292
What started as a routine eviction dispute suddenly took a dramatic turn. The tenant claimed the home was filled with mold, damaged plumbing, and unsafe living conditions. But the landlord argued something very different, that the tenant's actions may have contributed to the problems. Now the judge faces a difficult challenge, separating allegations from evidence while protecting both the property and the tenant's rights.
with what ostensibly is another addendum that wasn't in the file that was provided to me that extends this lease. So I'm kind of lost too.
All right. Is that correct? You gave him something that might change. I don't need to see it, but you did do that. All right. So I can go to 31st or the 7th.
If we could go to this, what was the second date? 7th?
7th, November 7th.
We have a young child that wants to celebrate the event.
So do I, but I got to be here. What? No, never mind. I'm kidding.
No, it's not now. Your holiday.
What'd you say? Well, I don't like people coming to my door wanting things. That's just me. All right. I'll adjourn this to November 7th, 2025 at 1 p.m. All right. Pardon? Yes, in person. All right. Thank you, ma'am. Thomas Berry versus Serenity Struman.
Good afternoon, Your Honor. Either case 27292 for repairing the building.
All right. And this, I almost hate to ask, but where are we on this one?
This, Your Honor, we are ready to proceed with the hearing. I don't know if you're prepared to do that this afternoon or if you want to set it for another.
Well, I'd have to set it for another thing. I was unclear when these two appeared the last time as to exactly the basis for a basis for the health hazard.
The basis for the health hazard, Your Honor, I would have those kind of broad. You don't have enough of them. This, I was just retained on this case a couple of days ago. The fact of the matter is the health hazard, as my client was seeing at the time, was the number of dogs.
Was the dogs, right?
Frankly, I don't think that really applies to a health hazard per se. So
I don't think it does at all. At least it was explained to me. I mean, you weren't here at the last hearing. Your client kept going forth talking about a violation of an ordinance, which clearly would not relate to a health hazard in this instance. The very fact that somebody has 4 dogs doesn't declare themselves a kennel, doesn't make it a health hazard.
well, I understand that, which is why the drawing that, but the other claim in this was a 30-day notice to quit. That we're proceeding to that.
Just 1 second. Well, counsel, we got a problem.
That's fair.
because the only demands for possession that I have as part of this case are a health hazard.
Your Honor, I have this, domestic privilege was
Well, which was what?
really defendant. Henry Carter.
Okay. And it may very well have been. However, I don't know how even if I took the notice, I don't know that I can do anything with it because the only issue that was raised to the court is the only complaint I have. So the only notice I have and the only complaint I have is a health hazard and damage to the premises, which again goes to the dogs in the house. So that's the only complaint I have. I don't have.
Yeah, this should have been in there.
What should have been in there? Okay, so council will know what I'm talking about.
Yeah.
I have a health hazard notice. The only complaint that was filed was a health hazard complaint. I don't have a termination complaint. I only have a health hazard, which again relates to the dogs that hopefully we've cleared up. When she responded, she filed an answer based upon the health hazard complaint. That's all I have. Counsel, I think if he's going to proceed on something else, unless he wants to try to pursue this thing with the dogs, this thing's going to have to be dismissed and he's going to have to start again. All right.
I should hear and we'll refile it.
All right. Was there anything you wanted to say?
Did you get the letter that I wrote that was attached to the answer?
I got everything that you sent in. Okay. But I mean, you know what? Yeah, sir, I'm going to tell you what. You better check how you're handling yourself in here.
As the hearing nears its conclusion, the focus shifts from legal paperwork to courtroom conduct. Judges expect respect from everyone who appears before them, regardless of the outcome. What happens next serves as a powerful reminder that how you behave in court can sometimes leave a stronger impression than the case itself. And this judge is about to make that point crystal clear.